Tonight's topic is things that you might want to know about eminent domain and Minnesota landowner rights. Tonight we have a Minnesota native here tonight, although he's living in North Dakota. I'm going to let you tell a little bit about yourself, Derrick, but Derrick Braaten is with us to present tonight. So Derrick, if you want to take it over.
Thank you, Peg. Appreciate it. So I'm originally from the Bemidji area. I grew up in northern Minnesota, but I've been out in North Dakota a little over a decade now. And I moved out here originally to practice agricultural law, and I still do a fair amount of agricultural law, but I'll give you a little bit of background on my practice and what I do, just so you have a sense of what kind of questions I can answer and how I might be helpful. And I can ramble as well as any attorney. So if you want me to do that, I can, but I'm also happy to just answer actual specific questions people have. And I usually find that to be more productive and helpful. So a little bit of background: when I moved to North Dakota, as I said, it was to do agricultural law. And I worked with attorneys out here named Sarah Vogel and Beth Baumstark and Rudra Tam. Sarah Vogel was the former agriculture commissioner of North Dakota. And the firm really did primarily agricultural law for family farmers and ranchers. And then the oil boom started in 2007, 2008. And we started getting a lot of calls from farmers about issues in the oil field. And initially we said, you need an oil and gas lawyer. That's a very specialized area. And inevitably 6 months later, they'd call us back and say they tried every oil and gas lawyer in the state, and they're all conflicted out or too busy because they're working for the oil companies. And so our firm just decided to start doing energy law. And so we do oil and gas law, and we work with landowners on essentially all energy development, whether it's oil and gas or coal mines or solar or wind farms, and now carbon projects. And I do a lot of that type of work, both with respect to landowners with damages on their property. For example, they have wastewater spills in the oil field on their property and need to get it cleaned up or collect damages, or both. I also just help with negotiations, whether it's a wind lease or pipeline easement, things of that nature. And then I handle a lot of eminent domain actions for landowners. And I've also done a lot of work in North Dakota on recent legislation related to pore space and the rights landowners have in pore space. And so almost unwillingly, I've become very familiar with a lot of the law surrounding the use of subsurface pore space. And so one of the things I'm doing out in North Dakota is representing a group of landowners who are in the actual injection zone for the Summit Carbon Solutions project. And they've all been approached in that injection zone for leases of their pore space, as well as their surface for the actual injection wells and all of the other surface structures they'll need to do the actual injecting into the storage area out here in North Dakota. So I've been working with those landowners. I've also started getting calls from a lot of landowners around the state related to the pipeline easements, and I haven't done anything with that yet, but I will, likely be representing some group of landowners with respect to the easement acquisition out here. And I've worked a lot. I guess the final thing I'll say is I've worked a lot with landowner groups, and I know there are other attorneys that are working with groups. And one of the things I'll say is, whether you're working with an attorney or not, I do very much encourage landowners to get into groups, even if it's just you and a few of your neighbors. Your leverage and ability to negotiate goes up significantly. So to the extent you're negotiating anything, I do recommend that. But back to the practice area, the other thing I should tell people is that my focus obviously is North Dakota. I know North Dakota law very well. Certain things I know the law in other states. And so I'm generally familiar with Minnesota law. I'm licensed in Minnesota, but Iowa, Illinois, South Dakota, I'm not going to know as well. But there are also certain principles of law, whether it's related to trespass or eminent domain, that are going to be the same in any state. And so I can speak to a lot of those issues generally, if not very specifically. So I think with that, Peg, that probably gives a pretty good idea of what I'm able to speak to and the kinds of questions I can answer. I've got a few of your questions that I jotted down when we talked earlier. I could start in on those unless you wanted to open it up to other people for questions first.
I think, Derrick, that I'm just gonna, since a bunch more folks have jumped on, I'm just gonna say we're gonna use the chat feature and the raising hand feature in order to be recognized for asking questions. And if you have a question, you can raise your hand. Otherwise, I think we'll have Derrick start with just a basic overview of what is a we're not dealing right now in Minnesota currently with eminent domain for this project. So maybe, Derrick, if you could just start with what is a voluntary easement and what does that look like for a landowner?
Sure. So a voluntary easement, essentially what you're giving them is the right to conduct certain activities on the land. And the main point, I guess, I would want everyone to take away is that when lawyers talk about, or the law talks about a piece of property and ownership of property, we always have an analogy or a metaphor we use, which is the bundle of sticks. And what we say is that when you own a piece of property, you have a bundle of sticks, and that bundle of sticks represents all the various rights you have in that property. And so you have a right to exclude people from your property, which is the most important right that comes with property. But you have other rights associated with your property, such as the right to sell it, the right to encumber it and put it up for security, and a number of other things. And then you have all of the actual uses of your property. And so the way to think of it is that an easement is one or probably a handful of sticks in the bundle. And what you're conveying to Summit, or what you're giving to Summit, is a number of the rights and the sticks in the bundle of property ownership. So essentially you have a certain number of rights, and you're going to take a certain number of those rights and give them to Summit. And there are then going to be certain situations where Summit, or whoever is taking an easement, is going to have superior rights to you on your land, even if you're still the owner. So the reason I say it that way is it leads into something else I know is a concern in Minnesota and should be, which is that they are seeking permanent easements. And I guess the short way that I can address the idea of permanent easements is that we literally do not have those in North Dakota because they're illegal. And to be totally candid about how that came about out here, I have a feeling, this was before I think I was even here, but I think historically in North Dakota, there were concerns more about actual conservation easements being put on land in perpetuity. But there was a law passed in North Dakota that just said any easement on land is limited to 99 years. And so if you look at any of the easements that are being proposed in North Dakota, they all say a 99-year easement. Even if it says permanent, it's still a 99-year limit. And so what I can say, though, is for anyone in any other state, what I would tell you is that's what your law should be. And I as a attorney that works primarily on property rights and with farmers and ranchers, anything permanent with property, to me, I think of as just assume you're selling the property, because, and it's not true, like you can still farm the property, you still own it. So that's not what I'm saying. But the idea to me that you're selling off a permanent right in property is very concerning, and it's not something I would recommend to a client that they do unless they are also prepared to essentially, lose their rights to that property, essentially sell that property. So I have some other things I can say on that note, and even some related to compensation, but I'm just going to pause, Peg, and see if there are any questions or people raising hands or anything yet.
I'm not seeing any hands as of yet. I do know that one of the questions, as you're talking about permanent easement, and when you have a permanent easement, you still have you lose rights, but you have responsibilities that don't go away, right? You still have to pay property taxes on that easement and insure that easement if you can get insurance on the easement. And so those are like some things that people have asked about, if you have some clarifications on those thoughts.
Yeah, and some of that is going to come down to terms of an easement, and this is why the language and the terms of the easement are important. And what I can say is that I don't need to pick on Summit even here. From pretty much any developer I have ever encountered, I've never seen a pipeline easement proposed that I would let one of my clients sign. It needs significant work, and I've seen Summit's easement. I've seen a couple in North Dakota, and I've seen the one in Minnesota. They all look to be pretty much the same, with some distinctions based on state law, like I said about the 99-year. And so those are good questions, and what they go to is some of the terms that you would need in an easement in order to allow this on the property. And so, those are good questions about liability, and I'll speak to that. There's also very practical questions about, speaking of responsibilities that come with it. Yes, there are, and they can be a big headache, such as people opening your fences and not closing gates, and your cattle are out, and that's your problem now. And erosion on the pipeline right of way, inviting in noxious weeds that now you're responsible for, and legally responsible for as well. And so those are the kinds of things that can be addressed in an easement, and you can do things to actually shift that liability. So with respect to noxious weeds, what I would normally recommend is that you just say they are strictly liable, and strict liability is a legal term that essentially says there's not going to be a debate about whether they were negligent or not. It's just they're responsible, period. And what you're saying is they're responsible, period, for noxious weeds in the right of way and for eliminating them, and that they will indemnify you if you get, the county weed board calling you about it. And so there are practical ways to address some of those things. Additionally, insurance is a big one that should absolutely be in there in a major way. It's, something I would put in at the very least, you need a provision that simply says they will have a general liability insurance with, coverage in certain amounts. And, I don't know if I can make recommendations on those amounts, but, you should set, a minimum coverage level. It's definitely in the millions, and have them add you as an additional insured to that insurance policy. And what I can tell you is a lot of the things, all of the things that I'm going to tell you folks, this is the disclaimer I should have done up front, but all of the things I'm telling you that I would recommend you do in an easement, I want you to know that I have done, and I've done it with oil companies and major pipeline developers. And so the reason I say that is if you say these things to the landmen, they're going to tell you you're crazy. And I just want you to know you're not, and I'm not. And these are things that major pipeline developers and oil companies have done on a routine basis out here. That said, I need to tell you all also that I'm not giving anyone specific legal advice tonight. because I just don't know your situation and I don't know all of the facts. And so I don't want anyone to walk away thinking that I've told you if you stick this provision in your easement, you're fine and everything's going to be okay. But I also want to give you as specific and helpful information and knowledge as I can. And so I'm going to do that. And I'll also just let you know that when I'm telling you I would recommend this or that, I'm telling you things that I have actually done in easements with major developers. And the reason I say that is they will definitely tell you you're crazy when you want to do things like have them add you as an additional insured or have a 99-year limit or reduce the width of the easement, but those are all perfectly legitimate and reasonable things to ask and do. The other thing with insurance is it can get pretty complicated when you're talking about major commercial liability insurance. And so I've actually learned things from clients, to be honest, about, insurance provisions and what to include in leases and easements and things like that. So it's certainly something where you can get a lot more detailed. And, the kinds of things I'm talking about are, for example, if you say they need to have a $10 million general liability insurance coverage, and that's for their entire project, and you're listed as an additional insured, that's all well and good. But what if they have a $7 million claim on their $10 million policy? You want, at the very least, for them to notify you when they've got those kind of claims on the policy, so you know that there's additional exposure potentially because their insurance is just going to max out. So you can really get in the weeds on additional provisions. And these, again, are all things that, are pretty common in the industry. So it's not unreasonable to ask for that kind of detail. But it's certainly not unreasonable to ask them to simply have insurance and add you as an additional insured. That should be done as a matter of course, in my opinion. And then there should also be very strong indemnity and liability language. And I'm certain that they've got indemnity language, but generally it's, first off, it's going to exclude your negligence. And I recognize that it's not fair to them to have to pay for a landowner's negligence, but I've seen the way that often plays out in litigation. And you need to be careful that they can't just make, some kind of a claim that, well, if you would have done this or that differently on your land, this wouldn't have happened. And so that's a problem with that indemnity provision. It's one of those things where the exception can swallow the rule. So, getting that language out about negligence and at least turning it to something like gross negligence. So they have to indemnify unless it's due to the landowner's gross negligence rather than their negligence. That's a significant change, even though it's just one word. And so the indemnity provisions, what I'd say is they all like to say, oh, well, of course we have an indemnity provision and we'll indemnify you, but indemnity provisions are very legalese. They're written in legalese, and the legalese has significance. And so with those provisions in particular, you usually do want an attorney to look at it because, as I just said, you can add one word and it'll very significantly change the meaning and the coverage of that kind of a provision. So words matter in a lot of these agreements, and they matter more than a lot of people know. Lawyers actually make a lot of money fighting over the placement of commas in sentences. And so it's something that's frustrating about the practice of law in the legal profession and the way all of this works, but it's also something that you have to be very careful of because fine print is real and it means something very real on your property when you're signing an easement. I'm going to pause there, Peg, and just I can move on to some other topics, but just see if there's anyone that has any questions on anything I've talked about so far, or just questions you've been wondering about in general.
I'm still not seeing any hands go up or any questions in the chat, but if you have a question, you can type it at the bottom of your chat window. A couple quick questions. In Minnesota, this is going to the PUC for consideration to include or amend the definition of hazardous liquid to include carbon dioxide. and that's happening here shortly. And when you have a pipeline with a hazardous material running through your land, I think that, you know, there's recommended distances that their buildings and property, like, you know, well, first of all, buildings should be away from the easement. I don't know if you have experience with recommendations on that. People have been asking, like, you know, with a standard easement, there would be things like no trees on the easement, right? No vegetation that is over a certain height. There would be issues around, one of the concerns that came up, that was a question from someone, was how does an easement impact your land value and your property value when going to sell? Like, does it make it harder for you to sell your property when you want to sell it, if truly you want to?
Okay, I'm gonna start by just saying I've got a case and client out in Montana, and there's a large oil field being operated out there, and it's in what we call enhanced oil recovery, or EOR. But they're doing a CO2 flood, and that's where a lot of the research on CO2 sequestration came from, is not sequestering CO2, but using it for CO2 floods in the oil field to produce oil. For that reason, he has a network of CO2 pipelines and so forth going across the entire property. It's probably more extensive even than one of the sequestration zones for injection, because it's an active oil field as well. I was just looking and I can't find them, unfortunately, and they might be unnecessary. But what I was going to say is that in terms of setbacks, things like that, I don't know offhand, but I can tell you that, you know, obviously CO2 is what it is, and if you have a little bit leaking into the air around you, it's probably fine. But the concerns from a public health and environment standpoint would be obviously a major CO2 leak, and I think this is more a concern around the sequestration areas, but a major CO2 leak in a low-lying area can suffocate basically anything in the area. And so it's a concern, but it's a very low likelihood concern. It's one of those things where consequences are very high, likelihood is very low. More likely are things like, one of the things we've seen in the EOR fields is when they use fiberglass line for the CO2, it builds up moisture in it. And as the moisture builds, temperatures change and essentially they blow up. And so, you know, the client had, for example, a road, and I would say there was a 10 to 15 foot diameter crater that went about 10 feet deep, that took out a good chunk of the road. And again, this is a fairly remote area. It was a ranch. There was no one around when that happened. So that's fine. It's very low likelihood that someone would have been driving over that exact spot right when it exploded, but that would have been very bad if that had happened. More common problems that you'll see would be another thing that he has seen, driving your four-wheeler across the pasture and whoop, there goes the four-wheeler, and it's down in a 7-foot sinkhole that is over the pipeline area. And so those are the kinds of things I would say in terms of those setbacks, but that kind of feeds into the other question and what I'll talk about, which is, you know, sort of a combination of land values and compensation, and how does it impact your land values. And what I should say to start with, before I talk about the land values issue, is that there's ongoing debates in the courts about how we do this and how this happens. And so it's kind of a moving target, and we're all finding that out together right now. And the reason for that is that what we've seen in the oil field is that as you increase pipelines and pipeline development, what you'll find is that there are actually markets that develop around that. And what I mean by that is out here, if you go up to McKenzie County, North Dakota, and that's in the center of the Bakken oil field, if you go up to McKenzie County and just ask any landowner at the gas station what's going rate for a pipeline, or what are you getting for surface well pad agreements, they all know the rates. And the point is, and I've actually hired economists to testify in litigation about this issue, but what's happening is there are actual markets developing around the trade and conveyance of the property rights that oil companies need to do this. And they're developing in ways that aren't consistent with the way that appraisers typically look at property values. So what you'll see is in McKenzie County, an appraiser will go up there and say, yeah, I appraised your property, $1,000 an acre for the pasture land and $5,000 maybe for the tillable cropland. And, that's the value. And the McKenzie County landowner is sitting there saying, oh yeah, well, I just sold a pipeline easement for $150,000. And in the last 3 years, I've sold $2 million worth of pipeline easements. So I'm not going to part with my land for $5,000 an acre if I can make that much money off of having the land, whether I'm farming it or not. And so you're really looking at a situation where one of the main land uses becomes selling easements to oil companies to run pipelines. And like it or not, the problem for a lot of landowners is that they don't really have a choice up there. It's going to happen whether you sign an easement or not, because if you don't sign an easement, they're coming. And we'll get to that here, but luckily you're in a situation right now in Minnesota where they don't have eminent domain authority for this line. And so they're going to have a much harder time pushing it on people who just say no. Gives you a lot more leverage to negotiate too, if that's something you wanted to do. But back to the land values, the reason I bring all of this up is that when we're talking about what you get paid for a pipeline, what the pipeline company is going to tell you is, well, we're paying you the full fee value of your property and we're only taking an easement. And so really we're paying you way more than we should because we're only taking some of the rights and we're paying as if we're taking all of the rights. What they're not saying is that they're paying you for agricultural use, but they're not running cattle and they're not growing corn. They're running pipelines. And so the way I talk about it out here is that in McKenzie County, there's a rate for running cattle and there's a rate for running pipelines. And if you're running pipelines, you pay that rate. And so what they're going to tell you, particularly in Minnesota and basically anywhere outside they tell everyone in the oil patch this too, but especially outside the oil patch, they're just going to tell you, here's the value of your land. Well, it really depends. And what I mean by that is that as we're seeing more pipeline development, the rates that they pay for pipelines in the oil patch are going to start expanding out, just as we are going to see carbon pipelines supposedly coming from Illinois and Iowa across Minnesota and South Dakota and into North Dakota. If that's really going to happen, then those rates should be expanded from the oil patch out to these additional lines. When I say that, it's not unprecedented. And what I mean is that that's how it gets done in North Dakota already. When Dakota Access came through, when Cenex came through, when others came through, most of those companies understood how these markets work, and they went up and they found out what the going rates were and they started paying them. And so Dakota Access came in and they certainly started low, but fair enough. But they still pegged it to actual market rates in the oil field at the time. And at the time, I think it was $350 a rod or so, maybe $400 a rod. And that was quite a few years ago, but that's in McKenzie County. And so they started there, but the groups, and again, this is why I do recommend groups. The groups got a much larger amount, between $600 to $700 a rod. And then there were some people close to cities where they're looking at the potential of the actual commercial development land, who got up to 1,000 a rod. And so when these other pipeline developers are paying those rates, it's recognition that it's because there's a market for them and we know what those rates are and those should apply. You know, if anyone ended up, and you don't have this problem, but if people ended up in eminent domain proceedings, that's really what the fight would be in eminent domain proceedings, which is how should we value this easement? Should it be based on what companies pay for other similar easements? Or should it be based on how much an acre of tillable land is going for in your county? And what I'll tell you is, I'm probably pretty clear what my opinion is, but federal courts in Montana have agreed with me, or federal courts in North Dakota have agreed with me, that you look at the pipeline easements as evidence. And so, you know, expanding that to Minnesota is a step further than North Dakota courts. But it is certainly not unreasonable to tell them that, hey, I know what the rates are for pipelines in North Dakota. I know what companies pay for pipelines going across agricultural land out there. And for the record, it's $6.50 a rod right now. And to be fair, that is McKenzie County, and that's a different world. I'm not saying that I think everybody along the summit line should get, well, I do think actually that everyone should get $6.50 a rod, and probably a lot more than that. I'm not saying that's going to happen, but I do think it would be reasonable for them to be starting out right now at closer to $500-600 a rod. And what I'm saying, when I'm saying that, it's not because I'm, you know, some crazy guy out here saying that. I'm saying that because that's what Dakota Access did, and that's what Cenex did, and that's what other big pipeline developers have done. And so, you know, they're going to have a tough time out here, because it's one thing if you're down in Sargent County in the far southeast part of North Dakota saying this, but if you're going to tell any landowner in North Dakota in the western part of the state that they're going to pay less than $300 a rod, they're going to tell you to take a hike. So I can, and, you know, let me throw that out there. If people are shy about asking questions, if you want to know more about how much you should ask for per rod, I'm happy to talk about it all night. So feel free to ask questions about that too. I can tell you what rates are and what rates have been paid for various pipelines. But the thing I'll finish on, and this kind of gets complicated at this point, but I want to go back to land values. And there was also a question about land values and how all of this works with land values. And that's where this gets really difficult and complicated, because someone could make a fair argument that, hey, you know, if you're saying you should get this much money for this pipeline easement, that's literally more than you could sell your land for. That's not logically possible. And it's a fair point, but what it doesn't recognize, and the answer to that question has to do with something we call capitalization. And all you're really talking about is, has this value that your land can be put to, i.e. running pipelines or a pipeline easement, is that something that is showing up in the land value at this time? Not yet. And that's the problem, is not yet, but if you're in the path of this one, and then another one comes, then it's going to start getting capitalized in the land value. And if you wait for that to happen, it's too late for you to make any money on that increased value of your land other than by selling the land. And so I know that that's complicated, and I don't pretend to be super smart about economics. I've just hired economists to tell me these things, and I'm just repeating what they've told me. But it's really a complicated issue when you talk about land values. And the answer is that no, it's not going to have an immediate impact on land values one way or another. And the way the appraisers look at this and what they're going to say about it is that if I went out and I took 10 properties in rural Minnesota that have a pipeline easement, and I went out and I took 10 properties in rural Minnesota that don't have a pipeline easement, and I matched those up so that I've got a quarter section that's sold here and a quarter section that's sold here, and they're both tillable, non-irrigated land. And I've got a quarter section here that's pasture and a quarter section here that's pasture. And so they're going to match all of those up, and they call it a paired sales analysis. and they say, okay, there's all of these that sold that had a pipeline and all of these that sold that didn't have a pipeline. And hey, look, on average, the values for the ones with a pipeline versus without a pipeline were not different at all. They were maybe within 3% of each other, one way or the other. And that's probably what you're going to find. But, you know, the devil's in the details. And first, you got to ask, what kind of pipelines are you talking about? And so I had one appraiser in a case that answered that, and she was talking about rural water pipelines around Fargo, and we were talking about oil pipelines in McKenzie County in the middle of the Bakken oil patch. And that's a little different. And so the reason I say that, though, is that no one's done a paired sales analysis on CO2 lines running to a 12 million ton a year CO2 sequestration facility in North Dakota, because none exist. And all of the talk right now, and anyone watching markets or anything like that, is going to tell you that this CO2 sequestration is the next big boom. And, you know, there's a lot of policy discussions going on around whether that should be true or is true. But the reality from a market standpoint is that that's what the industry is saying is true, and that's what they want to be true. And so in terms of projecting markets and economics, the projection is that land values are going to increase in the path of these projects, because you're going to start seeing additional land uses and values for land uses that you haven't seen before. And that land is going to increase in value as a result over time. Whether or not you as the landowner can capitalize on that is going to have to do with whether you're signing easements and eminent domain and all kinds of things. So mainly just because I've been rambling for a while, Peg, I might just pause and check to see if there's any questions or anything that you want to inject based on what you know.
Sure, Derrick, thank you. So to the point that you were just talking about, I would just mention a couple of things. First of all, I would say that most infrastructure projects like this are amortized over 20 to 30 years, meaning that that's what they anticipate the life of the infrastructure to last. So once it's fully operational, it will be generating income for whoever owns the pipeline for that period of time, and it will be going through your land. And the easement payments as they're being proposed at the moment are one-time land payments and a 3-year crop payment of what the industry would refer to as a 240, where they give you 100% of crop loss on the easement the first year, and then 80% the second year and 60% the third year, with the hopes that everything would be back to normal after 4 years. But for those of you who were on Janet's presentation last time we met, you saw examples of several years later where the soil was not producing like it was prior to the easement, and there were challenges with the crops production. And so those are important parts to think about. And Derrick's right. Nationally and even globally, there are industries that are hopeful that carbon pipelines are going to be moving forward and be very prolific, but there's also realities that because they're new, they're realizing that there are problems and challenges with them that might not allow them to be as prolific or moving forward in this new next best thing. Derrick talked a little bit about these easement markets for land and payments that are really different. I hadn't heard those crazy dollar amounts before up in the pipeline corridor, but I can only imagine it makes sense. One of the things that we've seen, Derrick, and I don't know if you've had this experience in North Dakota, but in southern Minnesota and in other parts of the country, they have what I think are termed as community benefit taxes from these types of industries, where communities can negotiate as part of the landowner negotiation and community, like permitting negotiation through the county boards or whoever the regulatory government unit is, benefits for your community, where we have some communities in southern Minnesota that these community benefit taxes that the industry pays, in that case, it's the wind industry, I believe, for transmission through their county, covers their county budget, has payments to their school districts, and also their healthcare facilities. Do you have experience with that, Derrick?
I know of that, and I have some experience with something similar, kind of within the community wind model, but more like large groups of landowners working together and doing things like revenue sharing. And what I'd say is most of I think that happens out here, for example, with all of the wind projects, but it's just not called that, and it's just, we straight up call it taxes. And but there are specific, like with every energy extraction industry, there's going to be certain kinds of taxes, and we have a pretty elaborate structure set up to make sure that certain amounts of that are going to those local communities for those specific kinds of projects. So it's more of a statewide mandate, I guess I'd say.
Sure. We do have a question from Dan. He's on the phone. Dan, can you unmute yourself? I'm not sure, Anne, if we can unmute him, being that he's on the phone. Oh,
there we go. Can you hear me now?
We can.
Okay, my question was, he was talking about the price per rod. Now, is that meaning the price per rod of pipeline? So if the pipeline goes 10,000 feet through your property, he's saying that much per rod of pipeline, or what? I guess I'm not seeing how that translates to dollars per acre. I guess that's my question.
It's a good question. And so out here in North Dakota, we do negotiate over and argue about the width of the easement. A lot of the pipeline easements in the Bakken are 50-foot easements. So there is a fairly standard easement width, but what I'd say is that, we talk about the going rate for a pipeline and rods. And I should say, this is familiar to me, but for anyone on the call that doesn't know, for whatever reason, we always talk about pipelines out here as per rod payments. A rod is 16.5 feet. So whether it's a 50-foot easement or a 75-foot easement or a 30-foot easement, most of the time we're still going to just look at the same rate per rod, and it's just based on that linear extent. And so, whatever that linear footage is going across your property, you just convert that to rods to do the equation. And so if it's 10,000 feet, just divide it by 16.5. And that's what we're talking about as a payment per rod, is just every 16.5 feet, that's what they pay. So yeah, in North Dakota, what we are seeing in McKenzie County, it's primarily gathering lines, but other kinds of pipelines too, about $650 a rod. And so what that translates to for everyone is $650 for every 16.5 linear feet, whether it's 50 feet or 75 feet or 30 feet in width. And so you can't necessarily translate it to a per acre number, because it could be slightly different depending on the width of the easement. And I know that sounds confusing, but it's just kind of how it works out here. And then the landowners will also usually try to squeeze them down from 50 feet as low as they can get them. And if they can get them down to 10 feet, they will, but usually it's maybe 30 feet or 40 feet that you can squeeze them down to. No, it's not a per year, it's a one-time payment. So that's, a $650 a rod. The other thing I'll say though is damage payments should be indefinite and forever, because they can come back in and do repairs later and cause crop damages. You can also see a loss of productivity almost permanently. Sometimes you can see a boost in productivity if you've got, heat coming to the surface. I don't think you will with this, but some of the oil lines where they're heating it, I've seen where you actually have a little boost from the temperature. But at any rate, the damage payments should absolutely just be, it's similar to a crop insurance payment. It's not hard to adjust for a productivity loss on a pipeline right of way. You do it just like a crop adjuster does, but those payments should be there as long as they're not back to 100% productivity. And if that takes them 10 years, which it often does, they should be paying that productivity loss for 10 years. I would say that most landowners are going to say, I want an annual payment, and I think it's perfectly justified. I think you should ask for it. We've always asked for it. For whatever reason, interstate pipelines never pay them. Sometimes we've gotten them on gathering lines out here, but the big lines, I've never seen them, but I never discourage anyone from trying. The same thing goes for throughput. If you're saying, I want, a penny on everything barrel that goes through or whatever it is, I think it's great to ask for it. I've just never seen that happen with a pipeline easement. Now, with respect to sequestration zones and pore space, we're really viewing that more as like an oil and gas lease and a royalty payment. And the other thing I would say is I'm not necessarily saying that the per rod lump sum payment is the way to do it. It's just the way it's done out here. And that's not even necessarily because everyone thinks that's the right way to do it. It's just kind of what's happened. There's a couple of questions in the chat I'll try and answer quickly.
You take the eminent domain one and I'll take the pipeline leak one.
Sure. So private company using eminent domain, it is a very dangerous, so I'm very biased here and I have a biased opinion. That said, I think it's very dangerous precedent, and I don't think that's how eminent domain should be used. On a national level, we're going to see this go the direction of property owners, I think. But generally speaking, there's sort of a rolling back of the idea that private entities can use eminent domain. And so the courts and just the law in general is starting to go in the other direction. And so North Dakota, for example, has a constitutional amendment that says if you're a private entity, you have to be either a public utility, which doesn't mean you're publicly owned, but you still have to be a public utility that provides that service to the public and has your rates regulated, or you have to be a common carrier pipeline that is essentially open to anyone to transport through rather than, a private pipeline company. But those were restrictions we put into our Constitution in response to federal cases that essentially said under the federal Constitution, that's okay. And so you've had a movement from states such as North Dakota and others to limit the ability of private companies to use eminent domain, but I'm seeing it abused out here by pipeline companies who I do not think have eminent domain rights. But if there's no landowners there challenging them, then they can do it because no one says no.
Okay, so Suzanne is asking what a leak in a pipeline would look like. Well, remember from our sessions before that these pipelines are pressurized at a very high level. They're pressurized more than twice that of a natural gas pipeline. And so it's unlikely that there would be just a leak. It would probably be a rupture, and it would be pretty intense would be the thought. Remember that CO2 is colorless and odorless. In order to get it into the pipeline, they're converting it from a gas to a supercritical state, which is kind of like a gel, a thick liquid. And that's why they have to have the pipelines pressurized at such a high level to push that thick liquid through the pipeline. But there's all different parts of this process. Derrick had spoke to the fact that they're going to be sequestering it in North Dakota. So there's opportunities potentially for it to leak up from the ground there. In Minnesota, they're going to be capturing, the projects being proposed, all of the projects are proposed at ethanol plants where they're going to capture they've said they're going to capture the CO2 in the distillery fermenting vats. They're going to distill it to remove the water out because water is highly corrosive to these pipelines. With the mix of CO2, it turns into an acid. So they have to distill it and they chill it. When we think about chilling it, because CO2 can also be dry ice, you think it's going to be really cold, but we've been told that it's going to be chilled to like between 70 and 80 degrees to go into the pipeline. And then the pressure keeps it at that level as it moves it through the pipeline, if we're understanding what we've been told from the companies. Again, this is new. There are CO2 pipelines in other parts of the country that are much shorter distance, and they're mostly, as Derrick referred to, used for enhanced oil recovery. Because CO2 is heavier, it sinks, and it's, you know, when they inject it into the ground, into these saline caverns, it sinks and goes down. And if it's in an oil field, it pushes the oil up. Currently, right now, there's 12 companies in the United States that do this CO2, liquid CO2. And of the 12, all but one of them are using it for enhanced oil recovery. One of the companies is ADM, the Decanter, Illinois plant, and they're sequestering it in the ground. And they're the first ones to really do that and keep it in the ground and not have intentions to be using it for another industrial purpose at this point that we're aware of. I think that should answer also Denise's question. John is asking, does the pipe 6 inches, 8 inches, 12 inches make a difference on price per rod? What are your thoughts on that, Derrick?
Not usually. And I know, again, that sounds confusing because you would think it would. It's definitely a point in negotiation similar to the easement width, where, you know, the negotiation is going to be, well, hey, this is a bigger line than the last one, and you paid $500 in the last one, so you should be paying more for this one. So it's definitely the case that landowners are generally going to ask for more for a larger pipeline, but there is not, you know, anything, you know, when we're talking about a rate for a pipeline out here, we're talking about $6.50 a rod, whether it's 6 inch or 24 inch. The thing that is pretty closely related to that does often make a difference, though, is that, you know, a lot of these smaller lines running around within McKenzie County are what we call a gathering line. And then the larger lines that I would call these CO2 lines are similar to like a Dakota Access oil pipeline that is taking the oil, not moving it around the oil field, but taking it from our oil field out to markets in, you know, Illinois and Texas. This is more like that. And a lot of times that argument is made with these that, hey, I mean, we're getting $3.50 a rod for a gathering line that's 8 inches in the Bakken. I think we should get more than that for a giant, you know, oil pipeline carrying the entire production of the Bakken out to market.
So the time has actually gone quicker than I thought it was going to go. It's already almost 7, and we had said that we would go till 7:15. One thing I do want to address before we wrap things up, and I see another question there, but one of the things we didn't really touch on, Derrick, that I'd like to, especially since this is the phase that we're kind of in right now in Minnesota, is we did have a question around, do you have to let the company on your property to survey your property? Because that is, I've heard that you do, and I've heard that you don't. And folks are being asked to sign releases for that. And is there anything that people should be aware of if they're signing a release for a survey permission? And are there things that you would recommend if they are going to allow a surveyor? I know several people on the call maybe have already had surveyors on their property, but could you maybe talk about that briefly?
Yeah, and the short answer is they wouldn't be asking for a release if you didn't have the right to say no. But so what happens, and what I will say here is that there are some very specific laws on surveying, and especially as pre-eminent domain surveying, which this isn't obviously in Minnesota. In North Dakota, for example, and in a lot of states, there's a specific law that gives them a right to do pre-condemnation surveys when they're going to condemn land. And the law says they have a right to go on, even though they haven't condemned the land, to do that because it's not a permanent, you know, invasion of the land. But here's the thing. What that law says is that they have a right to do it. The law doesn't say you have to let them. And it certainly doesn't say you have to give them permission. And so the blunt way I would put it is what the landowners out here would say, or what I tell them to say, is just no. And if you think you have the right to do it, then do what you got to do. But I absolutely do not have to sign your document, and I absolutely do not have to give you the right to survey. And if you think I do, you know, show me why. but they don't. And so if they want to get on to do the surveys, the bottom line is that if they want you to sign something, they can pay for that, and they can tell you exactly what they're doing, and you can tell them that you're going to limit that, and you can definitely tell them foot traffic only and things like that. But if they want you to sign something, it's because you have the right to just say no. And so to the extent they think they've got the right to do it, I think your answer should be, well, then do it.
Okay. A couple quick things. Is it asking for an ambitious easement terms, especially with a group like this, does it act in a way to deter the company?
I'm trying to think of how to answer that. My short general answer is no. They're sophisticated business people and they understand how this goes. Maybe something I shouldn't admit is that, like, you know, a couple big pipeline companies where I've gotten, you know, $650 a rod. We said that and the company said, okay. And I thought, dang it, I didn't ask for enough. So when I've gotten $650 a rod and so forth out here, sometimes, you know, I've wished that I had asked for more. You're not going to, what I'm trying to convey and what I was saying earlier is that if what you're asking for is $650 a rod and anything else I've talked about, you're not asking for anything aggressive or extreme. You're asking for exactly what they should be giving you and what they should have proposed off the bat. But no, I mean, companies understand that it's a negotiation, and particularly with a large group, if you're coming in saying these are the terms, then those are the terms, and they need to, you know, obviously determine if things are economic for their project. But I guess what I can leave you with is we've run numbers on their project, and many people have run numbers on their project, and they can afford a lot more than they're paying the landowners here.
Well, and that is a good point, because they're making money for 20 years or 25 years. They're making a lot of money for 25 years, and a one-time easement payment is a one-time.
And the one thing I should share is for the folks in the sequestration zone for this summit project, what they're asking for in the negotiation is royalty, like a percentage of your gross revenues for the life of the project. And I think that's perfectly reasonable and exactly what they should get.
Right. So there was a question from Dave. So Summit has said in their presentations that they're proposing to access federal tax incentives, federal incentives for carbon sequestering. And in order to access the 45Q is what it's called, dollars, they can either put it in the ground and keep it in the ground, or they can take a less amount and use it for another industry. Summit, since we're talking about Summit and Navigator, I haven't heard the presentation from Navigator, but Summit has said publicly that they're going to sequester it. That being said, any company entering into this new type of project, because this Summit is going to be the first interstate carbon pipeline in the country. The tax incentive federal policy is written in such a way that it doesn't guarantee after the program sunsets, the 45Q sunsets, it doesn't guarantee that that it won't be taken out for another purpose right now, legally, the way that it's written to my understanding. I think the intent was there, but I don't think that it actually formally guarantees that it will stay there forever. That being said, some companies are electing to sequester it and use it and take the less amount, keeping in mind that there are taxpayer incentives and tax credits for multiple aspects of this project. So the pipeline company, the industry that's producing the carbon, the company that's hired to put it in the ground can get tax benefits or payments. And so there's a lot of federal public money that is available for this kind of project because of the challenges we face with CO2 getting out into the atmosphere. Again, it's all new. We haven't really gone through the whole entire process, the cycle of the process yet, so we don't know how much money is out there and who's all going to take advantage of it and how much is going to be made. But that's what we do know. There's one more question here that says, if land is owned more than one person, do all have to agree to the project?
So the short answer is that a lawyer could probably write a book to answer that question, because it's a very complicated and a very good question. I'll try to give you the short answer, but this is one of those questions where I got to say it depends, and it depends on so many things that without talking to you about every detail, I couldn't answer it generally. But what it depends on is, are they acquiring an easement or a lease? What is the full bundle of sticks? Is it an easement that runs with the land? And the reason for that is you get into things about, well, you're a co-tenant, and is it waste if you are selling this easement, or is it a benefit to the property? So it gets into these complicated things, but what I can say is, generally speaking, the pipeline companies do not want to go across a piece of land without all of the co-tenants or joint owners signing on, because, what ultimately they can say is that, hey, your co-tenant, the person you own this land with, you're a co-tenant, you're a tenant in common, or a joint tenant, as we say, but the person you own the land with, what the company can say is, hey, they gave us the right to come on. They had the ability to give us that right. If you got a problem with that, take it up with them. That might fly. And so the answer to that specific question, do you all have to agree? Not necessarily. I've never seen a pipeline company real comfortable going across a piece of land without getting everyone to sign on, though, because even if they can say in a court action that, well, hey, this is between them, not us, they're still in a court action. And so they'd rather not go there, I think, is the answer. If they do, it's just such a complicated question that without knowing exactly what the ownership interests are and what they're seeking, it's impossible to answer. But the easy answer is that, as a practical matter, they don't want to go there either. So they're going to be very hesitant to move ahead on a property if even they have 6 out of 7 co-tenants signing an easement.
Thanks, Derrick. You've given us a lot of really important things to think about tonight. We really appreciate your time being with us tonight. I think if we were to ask you just for a couple final takeaways, what would they be related to property rights and voluntary easements?
Never listen to or trust a landman. And I'm sorry if there's any landmen on the line or your family members are landmen, but they're paid to tell you what the company wants you to hear. And they're trained to tell you you're crazy every time you ask for something meaningful. As a negotiator myself, when I'm negotiating for landowners, I don't talk to the landmen. I immediately say, I will not talk to them. I'm going above them. I want to talk to the general counsel at the company, or someone with negotiating authority that can make decisions on what they will or won't agree to in the contract. Because that's the other thing. None of those landmen have authority to say yes or no to anything you're asking for. So what's the point? The point is that you're stuck, and without a lawyer, you're going to have to talk to the landmen. But I've heard the question, and I just want to say this over and over again. Anything that I've been talking about, and one thing I'll say is, if folks want to reach out to me, I'm generally okay sharing certain easements that I've negotiated, as long as you understand I'm not saying this covers all your concerns. But just to the extent you want to see that, yes, these things I'm talking about exist in easements with companies like Dakota Access, I can send you those. And so don't be bashful, don't be afraid, and don't be afraid to talk to your neighbors either. I know that's hard and you're not supposed to do that, but you should, and it's to your benefit to talk to your neighbors about what's going on as often as you can. There's power in numbers, so I think the landowners should get together.